The three applicants sought procedural guidance to petition the Supreme Court and for outstanding legal issues to be addressed before the resumption of the case with plea taking. Judge Chinhengo referenced Rule 32, which outlines procedures for expediting cases, and noted that there are instances where requesting the court's opinion, advice or direction is deemed inappropriate, particularly when such requests effectively seek legal advice rather than judicial direction. He contended that the two motions did not genuinely seek procedural direction, but rather legal advice concerning the applicant's queries about whether to appeal or to request leave from the High Court prior to filing the intended appeal. Consequently, the motions were struck from the roll.
I do not for one moment think that the applicants may not have valid issues to raise with the state or state functionaries. The point here is simply that the applicants must act as best they conceive and not ask the court what they must do to realize their objective or the intended objective. As with the first notice of motion, the second notice of motion also amounts to no more than a request that this court provide legal advice to the applicants. This court cannot do so. It is not its function to give legal advice to litigants. There are situations, and many of them, in which a court may give guidance to unrepresented criminal defendants regarding trial procedures, but those situations do not require the court to give any concrete legal advice. The conclusion that the applicants are seeking legal advice and not directions from the court as contemplated by Rule 32 of the High Court rules means that the notices of motion may not be entertained.
Judge said that he intends to proceed with plea taking and proceed with the trial. However, Mbanga Siomunji, appearing for some of the accused, said his diary is full and that he can only be available next year in February. Judge Chinhengo then inquired why he took up the case if his diary was packed and what is being done in Namibia in such instances. Ed Marondedze, appearing for the state, also said that Siomunji should not have congested his diary, knowing that the matter is to start. Siomunji took offense to Marondedze's comment about his diary.
Any lawyer of repute does not congest his diary. It depends on the work that is available. If my learned colleague does not have a lot of work, as he seems to suggest, that is not anybody's problem. Maybe at the office there's not a lot of work that they're dealing with. But any lawyer of repute has a busy diary. I do not invent a busy diary. It is the status, is just the situation that I find myself in.
On the issue of some defendants saying the case cannot start now, as they are still to make a number of submissions and motions, Judge Chinhengo said this can be taken care of as the trial continues. He emphasized his resolve to start with plea taking and the trial next week.
We know the stage at which we are in this trial. We know we are at plea taking stage. We had taken pleas on count 1 to 4, and the idea was to carry on with the plea taking. So all the other things people might say without reflecting exactly the stage at which we are in this trial. The stage is of plea taking.
The judge postponed the matter to August 27 for ruling on the continuation of the trial.